Hi friends, good morning. Welcome to UPSC World. This is Dr. Harinath Reddy, Director of the Institute. Today in this particular video, we will try to discuss an important concept in Indian polity, that is Constitution as a living document. So in the recent past, the then Chief Justice of India, Justice D.Y. Chandrachud, while giving a memorial lecture on Nambiyar, father of K.K. Venugopal, he referred to this concept of Constitution as a living document. Remember, on this concept, questions have come in the past, both in the PSIR optional as well as in GS paper 2. Indian Constitution as a living document. So there is quite an opposite concept which is called originalism. So then what is this originalism? Where do you find this? And what is a living document, and how Indian Constitution is a living document. See, the concept of originalism, we see it in the United States of America. That's what Justice D.Y. Chandrachud has said. In United States of America, the Constitution is interpreted in the light of the intent of the framers of the American Constitution, which means when the American Constitution was drafted, at that point of time, the beliefs and the values which prevailed till then, and what the fathers of the American Constitution have believed in, that forms the basis for interpreting the American Constitution. Which means in America, there is a perception that the Constitution is a document which remains static, it will not change. So it means that if the Constitution in any country is interpreted not in the light of the existing circumstances, but instead it is interpreted in the context of the prevailing beliefs and intentions which were there at the time of framing of that Constitution, that is called originalism. So America, a Constitution of United States of America, it is basically interpreted by the American Supreme Court by applying this principle of originalism. Unlike American Constitution, the Indian Constitution is called a living document. See, Jawaharlal Nehru said that Constitution is a living organism, is a living document like a living organism. We all know that for the organisms to survive, they need to adapt to the changing environment. On the same lines, any constitutional document which fails to adjust to the changing values of the society, changing aspirations of the people, changing needs of the situation, will remain irrelevant document. It will lose all its significance. But Indian Constitution was enacted in such a way that it is made a living document. So the Indian constitutional document is capable of changing to the changing values and aspirations of the people of that particular time. So in India, the constitutional document can be changed through an amendment by the Parliament under Article 368 and even through amendments outside Article 368. This is one way how the constitution can be changed to adapt to the changing circumstances. The other method of making the constitution to suit to the requirements of the time is the interpretations given by the Supreme Court and High Courts. So in India, the Supreme Court of India is the final interpreter of the Indian Constitution. So the Indian Supreme Court will try to give it a new meaning to the changed realities of the society, thereby making the constitutional document very, very relevant to the changed circumstances. For this, I can give a number of examples. In the recent past, in 2018, there was an important judgment decided by the Indian Supreme Court, Navatej Singh Johar versus Union of India. So this is a judgment given by 5-judge bench anonymously, wherein homosexuality among the adults in private through mutual consent is declared not to be a criminal offence under the right to privacy. And again, in 2017, we had one important judgment. We have K.S. Puttaswamy versus Union of India. This was a judgment by 9-judge bench given anonymously saying that right to privacy is a fundamental right. And we also know that in Shani Shinganapur temple, women were not allowed entry into temple. In Haji Ali Dargah of Mumbai, women were not allowed entry into the Dargah. Even in Shabarimala, women in the menstruating age were not allowed entry into the temple. But later on, the Bombay High Court and even the Supreme Court, they have given judgments allowing the women to enter into these temples. So this is how the Constitution of India is a living document. So Constitution of India is an enduring document. In the last 75 years, it has survived and it will continue to survive even for the upcoming future. If you take the experience of many countries across the globe, Soviet Union has experimented with 4 constitutions between 1918 and 1991. France experimented with 5 constitutions between 1793 and 1958. Unlike Soviet Union, unlike France, the Constitution of India, when it was made as a very robust document with a sufficient inbuilt flexibility to adapt to the changing times. So this is the greatness of the framers of the Indian Constitution. With a lot of vision, the constitutional document was made in such a way that it suits to the requirements of India. And it was made in such a way that it adapts to the changing circumstances. And the Constitution was having enough flexibility to change to the changing circumstances. If you take the classical federations like United States of America and Australia, they are very rigid constitutions. They cannot easily adapt to the changing circumstances. So keeping before us the experience of United States of America and Australia, the framers of the Indian Constitution has made our Indian Constitution to be more adaptive by making it more easy to amend the Constitution. So the Constitution of India is amended 3 ways. Most of the provisions can be amended by simple majority. That's the flexible nature of the Indian Constitution. But when it comes to things like fundamental rights and directive principles of state policy, they can be amended by the Parliament alone, by Lok Sabha and Rajya Sabha, but by special majority. A majority of the total membership and 2/3 of the members present and voting. When it comes to the rights of the states, when it comes to the distribution of powers between the center and the states, they can't be changed unilaterally by the center without the consent of the states. All these federal amendments, all these amendments which relate to federal distribution of powers between the center and the states, they can be done by Parliament by special majority, that is a majority of the total membership of the House and 2/3 of the members present and voting. And in addition to this, half of the states have to agree for this. The most important example for such an amendment in the recent past is GST, the reform related to goods and services tax, brought in through 101 amendment, is an example for such an amendment. See, this is how the concept of originalism and the concept of living document differ with each other. The Constitution of India is a living document, which means it is capable of changing to the changing circumstances. And this change is brought in either by Parliament through an amendment or by the Supreme Court through its interpretation. But you don't see this flexibility in countries like in the United States of America and Australia. These are more rigid constitutions. If you take United States of America, in United States of America, if you want to amend the constitution, it's very difficult. There, 3/4 states had to agree, along with the American Parliament agreeing by special majority. That's the reason why in the last more than 220 years, the American Constitution has been amended only 28 times. And recently, United States of America has witnessed the elections to the office of the President. So there are several problems with the present system of elections to the office of the American President. But because of the difficulty in amending the Constitution of USA, for a very long time, bringing in reforms in the procedure for electing the American President has remained without an answer because of the rigidity in the American Constitution. But unlike American Constitution, the Indian Constitution was amended 106 times in the last 75 years. So it means it speaks volumes about the flexibility of the Indian Constitution to change according to the changing circumstances. And then if you take America, there is one case in 2020 wherein the Supreme Court said under the American Constitution there is no fundamental right to abortion. Right to abortion is not a fundamental right under the American Constitution. This is an example for originalist interpretation, which means if the constitution is interpreted not in the light of the circumstances, but if it is interpreted in the light of what the framers of the constitution had believed in at the time of framing the constitution, that is called originalist interpretation. So you don't find this concept of originalism in any of the textbooks which you read for the UPSC. So this is a concept which has come in the news in the recent past in a lecture given by Justice D.Y. Chandrachud. That's it about the concept of originalism under the constitution as a living document. Thank you and all the best.